Welcome back to Case Briefs with Megan. Let's make this case brief. So we've been talking a lot about torts cases, and one of the biggest torts that you might have heard about is something called negligence. Now, negligence does not require intent. You don't need to intend to cause somebody to get hurt. It just means that maybe you were acting in such a way you just weren't thinking, you weren't being as careful as you should have been, and somebody got hurt because of your actions, and now we're looking for you to be the person that pays them back for their injuries. We want to make sure that they're fairly compensated. When we talk about negligence, we talk about 4 different elements that go with a negligence case, which are duty, breach, causation, and damages. For the purposes of this video, we're going to talk specifically about causation. And now there's 2 different kinds of causations that we need to look at when we're trying to figure out if somebody's negligent. And we're going to focus specifically on what is called actual causation, which we also call but-for causation. Think about it in the way that's like, but for somebody doing this action, the other person wouldn't have gotten hurt. But Megan, what happens if there's multiple people and multiple causes to somebody getting hurt? Don't worry. We're going to talk about that using the case Corey versus Havener. POV, you are a simple man named Henry Corey. There's cars and motorcycles and all these new motorized vehicles that have come out because it's the early 1900s, but you're a simple man. You like your horse and your wagon, and you're driving such down the open road. Wouldn't you know it, out of nowhere, you get these 2 guys, there's Lud Havener and there's A.L. Adams, who come up on either side of you and your horse simultaneously, and they're riding one of these little motorized tricycles, which we later call motorcycles. The kids drive up simultaneously past Corey's horse. Corey is dang nabbit these young kids, but Corey's horse loses his mind and of course flips the wagon over because he's scared by the loud noises, and Corey gets injured. So remember how I said that these kids drove up past the horse on either side simultaneously? That gets to the issue at hand, which is you have 2 people who did the same negligent thing, which is you probably shouldn't have been driving by that horse so close, you probably shouldn't have been making so much noise, otherwise horse wouldn't have gotten spooked and then Corey wouldn't have gotten injured. But because it happened at the same time and they both did the exact same thing, how can you tell who is the actual cause of this negligence case? At this point, it looks pretty impossible to tell the difference, even though these 2 kids actually had no idea who they were. They just happened to be doing the exact same thing at the exact same time. And now you have the question of who is going to pay for Corey's injuries, because it's either going to be Havener or it's going to be Adams, who is going to have to pay the full extent of the injuries. And so the courts actually decide that both Havener and Adams are equally liable for Corey's injuries. They're both liable for this negligence. Now, does this mean that Corey can collect payment, the full payment extent of his injuries from both plaintiffs? No. He's got to choose one of them. What matters here, according to the courts and their reasoning, is they say, look, it doesn't matter that these guys didn't know each other, they didn't plan this, that this all happened independently, and that you don't actually have very precise but-for causation for each one of Corey's injuries. Havener driving this way caused him to break his arm. Doesn't matter that we don't have precise but-for causation. Just the general, but for these 2 people doing their independent sort of negligent thing here, it caused another person to get injured. So therefore, we've got to be able to hold both of them accountable for this kind of stupid action. Another fancy term, if you want to get jiggy with it, this is joint liability. And if you learned anything from this case, please don't bring your horse on the Old Town Road.